Welcome everyone to OSHA Guidance on Employer COVID-19 Vaccine and Alternative Testing Mandate webinar. Thank you all so much for joining us. Our moderator for today's call is Suzanne Spradley. She'll be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we're unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recordings in the follow-up email. If there are any portions of this call that you missed, by Friday, you will receive an email with a link to the full recording. PowerPoint slides used during this presentation will be shared in the same email. At this time, I'll hand it over to Suzanne Spradley, Senior Vice President and Associate General Counsel, CCO at NFP. Suzanne, the floor is yours.
Thank you, Amber. We are fortunate today to have some outside counsel that we utilize at NFP, Evandro Gigante and Alex Downey from Proskauer. They are both employment attorneys, as I mentioned, at Proskauer, and really at the top of their game as it concerns all things COVID and advising their employers on how to navigate the current issues related to COVID and certainly with the mandate. Chase Cannon is also on, will help me answer questions at the end. We will not address them during the webinar so that we can give them plenty of time to get through their materials. If we have time at the end, we will be pulling questions from the chat to pose to Evandro and Alex. With that, I will turn it over to Evandro.
Thank you so much, Suzanne, and thank you, NFP. On behalf of Alex and myself, I want to thank you all for joining us today on this webinar. Obviously a timely one, to say the least. We could have said this at any point in the pandemic, but there is a certain feeling of uncertainty in the air. And right now, a lot of it kind of circulates around the ETS, the Emergency Temporary Standard that OSHA promulgated not too long ago, and which quickly became the subject of a whole lot of legal challenges. So let's go to the first slide. As Suzanne mentioned, Alex and I have been advising clients on all things COVID really since, I guess it was January of 2020 when things started to sort of bubble up, and have kept on top of every legal development, every regulation, every nuance, state by state, federal alike. Since then, and so we have, I think, a significant amount of experience in these areas and are happy to share that with you today to the best of our abilities. Next slide. So real quick, we're going to talk about just generally the current state of the pandemic, where things stand, certainly from the employer's perspective, as employers continue to navigate what is clearly, the most significant seismic event in, sort of employment and HR law in the last, I suppose, 100 years, and sort of where we stand now and where we where it looks like things are heading. We're also going to talk about OSHA's temporary standard. As I said, that too is pretty unprecedented. As for those of you who don't know, and I'm sure nearly all of you do, the federal government issued an emergency temporary standard that essentially would require employers to implement policies that would then require employees at all of these companies with 100 or more employees to either be vaccinated or test and mask, and that is a pretty broad sweeping rule. We're going to talk about the legal challenges to DTS, which have been voluminous, but thankfully have largely been consolidated into one particular circuit court. We're going to talk about religious accommodations, largely because that, apart from the ETS, which remains somewhat in limbo, religious accommodations do sort of top the list of topics that we've been speaking to our clients about. The context in which that comes up is a mandatory vaccine policy that would require employees to be vaccinated in order to continue their employment with a particular company. And then the requirement that if an employer were to do that, you would need to make accommodations for medical or religious needs. The religious ones being probably the trickier of the two, not to take away from the challenges associated with navigating medical accommodations. And last, we're going to talk about some employer action items that we see employers taking now, that employers should be preparing for as we look ahead into what will hopefully be a less tumultuous 2022. Next slide. So let's jump right into the numbers real quick. So this is just an optic, and if you haven't kind of been following the numbers the way we have, I'm sure it's felt to you as though over the last couple of months, there has been, or at least the last month, a pretty substantial uptick in the daily COVID cases on a national basis, and in many of the states that around the country, and that's not just kind of what we see in the data, but it's what we see in the guidance and the regulations, with some mask restrictions now coming into place, more guidance from federal government, the WHO, and others are seeing on the horizon an uptick in the numbers, which calls for, unfortunately, a bit of a revitalization of some of the earlier restrictions. Certainly not to the extent that we had seen earlier, at least not yet. But I think a lot of governments and agencies kind of have their finger on the trigger for some of those things. Next slide. So we can't ignore the Omicron variant. Obviously, you've all heard about it. The latest news coming off the news just in the last couple of hours is that Omicron is in the United States. The first case was identified in California a few hours ago. At least that was made public. So what I think everyone anticipated, would happen, at least everyone who's been following it over the last few weeks, has now happened. So what do we know? What we don't know? Well, certainly we know that it's here and will likely spread. What we don't know is how much more, if any, transmissible it is as compared to other variants. Top of that list, of course, being the Delta variant, which we've all learned is quite transmissible itself. We do know that the PCR tests that are used today in the United States will detect the variant, so that's a good sign. We don't know whether it causes more severe disease as compared to other variants. And frankly, and this is sort of probably one of the most concerning things that we don't know, is we don't yet know the extent to which the variant is reactive or responsive to the current vaccines that are out there. And of course, we can all imagine what it would mean if they aren't as effective as relates to this variant, and it becomes more prevalent. What that means for folks who've already been vaccinated or who just got their boosters and might benefit from a different variation of the vaccine. So these are all unknowns, but it's certainly things that we should be following closely, and in our local jurisdictions, I think. Because a lot of these policies and procedures, while national in scope, the pandemic has had varying impacts and effects depending on different jurisdictions and rates of transmissibility, and of course, also rates of vaccination. Next slide. So real quick, in addition to the OSHA ETS, which we're going to talk about in some detail, there were two other vaccine mandates that came out of the federal government in the last few months. One is a mandate that would require all federal government contractors to have their employees fully vaccinated. Initially, it was by December 8th. It was then extended until January 4th in terms of the implementation. It would apply to all newly awarded contracts at any location where there's covered employment, covered work happening. And it would cover any full or part-time employees who are actually working on or in connection with a contractor working at a covered contractor's workplace. Yesterday, the news out of the district court in Kentucky, I think, was that the court issued a preliminary injunction blocking enforcement in Kentucky, Ohio, and Tennessee at the moment, citing that in all likelihood, the president just doesn't have the congressional delegated authority to manage federal procurement in the way that he has through this contractor mandate. So while I think many federal contractors assumed that this would go into place as scheduled, I didn't think that it was subject to the same legal hurdles that perhaps the more broad sweeping federal OSHA ETS had. For the moment, it has been blocked in at least these three states. Next slide. Likewise, sort of from an industry perspective and sort of carved out from the broader OSHA ETS is the healthcare ETS, or the ETS that applies to Centers for Medicare and Medicaid Services, referred to often as CMS. That ETS was an emergency temporary standard that requires staff at healthcare facilities that participate in Medicare and Medicaid to be vaccinated. It required that they get their first dose by December 6th and be fully vaccinated by January 4th. It also required that employers in that space develop a process for reasonable accommodations in accordance with law. And it had, as a consequence, the potential termination of the Medicare and Medicaid agreement for facilities that didn't comply. On November 29th, a federal court in Missouri issued an injunction blocking enforcement in 10 states in particular that challenged the CMS. And yesterday, a federal court in Louisiana issued an injunction that blocked enforcement nationwide. So that too, for the moment, is on ice and subject to additional federal court challenges, appeals, etc. Now I'll turn it over to Alex to talk about the federal OSHA ETS that applies to more broadly employers around the country with 100 or more employees.
Great, thank you, Evandro, and thank you to NFP for the invitation to be with you all here today. We can go ahead and just jump right into the ETS. And by way of background, on September 9th of this year, President Biden announced that OSHA was going to be developing an emergency temporary standard with a vaccine or test mandate. And a key here is that it's not just a vaccine mandate. Employers, should this rule ultimately take effect pending the outcome of the litigation, will give the employers the option of whether or not they want to implement a vaccine mandate or an option for employees to be vaccinated or tested and wear masks. After about 2 months, on November 5th, OSHA finally published the ETS applicable to employers with 100 or more employees, which, as I already mentioned, will require employers to require employees to be vaccinated or be tested weekly and wear masks. The ETS is presently drafted, requires employers to comply with all these requirements by December 6th, with the exception of the testing requirement, which would go into effect on January 4th of next year. That said, on November 6th, the ETS was stayed nationwide by the Fifth Circuit Court of Appeals. And then, in light of the number of challenges filed in nearly every federal circuit court nationwide, on November 16th, the Sixth Circuit was selected in a lottery to hear the consolidated cases challenging the ETS. And we're going to talk more about the litigation involving the ETS in a little bit. So diving right into the substance, which employers are covered by the ETS? So employers with greater than or equal to 100 employees at any time the standard is in effect will be covered. And how do you go about counting those employees? So included in the count are part-time, temporary, and seasonal employees, remote workers, employees who work outside or off-site, and employees under the age of 18. One key thing here, which we'll see on the next page, is that there's a difference between who's counted and who's actually covered by the ETS. So even though employees who work off-site or employees who work outside aren't necessarily covered by the ETS, they are included in the 100 employee count. Excluded from the count are employees of independent contractors and employees of a staffing agency. The count is based on the number of workers on November 5th, 2021. However, according to the FAQs that were issued alongside the rule, if the employer subsequently hits the 100 employee threshold, that employer would then become covered for the duration of the ETS. So to take an example, if on November 5th, the employer has 105 employees, subsequently lets go of 10 employees such that they fall under the 100 employee threshold, they're at 95, they would still be covered for the duration of the ETS. However, the reverse isn't true. If an employer originally with 95 employees hires an additional 10 employees, bringing them up to 105 total, they would then be covered from the time that they hit 100 through the duration of the effective dates of the ETS. Another point, the count is done at the employer level rather than at the worksite level. So even if you have 2 employees at 50 work locations, you would still be covered as an employer, even though you don't have 100 employees at any one location. Another question that has come up is how to count employees of corporate subsidiaries or related companies. The rule here actually doesn't come from the text of the regulation itself, but the preamble, which explains that 2 or more related entities may be regarded as a single employer for the purposes of the 100 employee count if the related entities handle safety matters as one company, in which case the employees of all entities making up the integrated single employer must be counted. So you really assess whether or not safety matters are typically handled by one company, and if so, all employees under that umbrella would be counted. So that was which employers are covered. Now to cover which employees are covered by the ETS, the vaccination or testing requirements won't apply to employees who work fully remotely, work exclusively outdoors, or report to a workplace where no other individuals are present. As I noted on the previous slide, these employees will still be counted towards the 100 employee threshold in most cases, despite the fact that they aren't covered by it. Contractors and host employees with at least 100 employees are each required to ensure that they meet the ETS requirements for their own employees. So if you hire independent contractors, you are not responsible for the ETS with respect to those independent contractors. The entity employing the independent contractors would be responsible for implementing the ETS with respect to its own employees. And finally, as Evandro previewed, healthcare workers and federal contractors are subject to their own ETS and are therefore not covered by the OSHA vaccine or test mandate. So once you determine that you are a covered employer and you have employees that are covered by the ETS, the next step is to decide if you're going to implement a vaccination policy or a vaccine or testing policy. Employers that elect to require mandatory vaccinations without a testing option must adopt a written policy requiring that all employees be fully vaccinated. And the ETS defines being fully vaccinated as being 2 weeks after completing your primary vaccination series of a COVID vaccine that is approved or authorized for emergency use by the FDA or WHO. And as you can see, booster shots are not included in this definition. And that's not to say that employers cannot go further than what the ETS requires and require that employees receive booster shots. However, that's not required pursuant to the ETS, at least at this time. The ETS allows for exceptions for in 3 situations. 1, if an employee is medically contraindicated for receiving the COVID vaccine. 2, if there's a medical necessity that requires a delay in being vaccinated. And 3, if the employee is legally entitled to a reasonable accommodation due to disability or sincerely held religious belief. And we're going to dive in some detail on religious accommodations later on in the webinar. And finally, the ETS and the FAQs encourage employers to refer to the EEOC's website for assistance in evaluating accommodation requests. The EEOC has issued rather detailed guidance on accommodations in the COVID context, including accommodations related to the COVID vaccine and in particular, religious exemptions from a vaccine mandate. Employers that are collecting proof of vaccination must maintain 2 things. First, they must maintain for each employee acceptable proof of vaccination and also a roster of each employee's vaccination status. So just visually inspecting each employee's vaccination status when they walk in the door will not be sufficient under the ETS. The ETS actually requires the employer to collect a physical copy. The roster must list whether each employee is fully vaccinated, as defined on the previous slide, partially vaccinated, not vaccinated for a medical or religious purpose, or not vaccinated simply because that employee hasn't provided acceptable proof of vaccination. So what is acceptable proof of vaccination? The ETS includes 5 options, which I'll go through pretty quickly. First is a record of immunization from a healthcare provider or pharmacy. The individual CDC COVID vaccination record card, medical records documenting the vaccination, immunization records from a public health, state, or tribal immunization information system, or finally, other official documentation that contains the type of vaccine, dates of the vaccine, and the names of the healthcare professionals or clinics that administer the vaccine. Now, if an employee has attempted but is unable to provide one of these 5 acceptable proofs of documentation, the employee, there's an alternative that allows the employee to provide a signed attestation that they are fully vaccinated. And this should really only be used as a backup of last resort in the event that the employee has actually attempted to get proof of vaccination in one of the acceptable forms and has been unable to do so. In which case, the attestation should state that the individual has been fully vaccinated. If they should need to attest that they have lost and are unable to procure the required documentation. And there's also other required language contained in the ETS that the attestation must include. So if the event that you have an employee who's unable to provide one of the 5 proofs that the ETS specifies, you'll need to go into the ETS and borrow the language from the ETS and have the employee include that language in their attestation. In the event that an employer previously collected proof of vaccination from all employees, there's been a lot of employers over the past year since vaccines have become widely available that have on their own implemented mandatory vaccination policies. If you as an employer have already ascertained the vaccination status in some other way prior to the ETS taking effect and retained records of that ascertainment, those employers are exempt from re-requiring proof of vaccination for those employees who have already provided proof of vaccination. So you aren't required to go through the process again. Now to turn to COVID testing for those employers that are opting for a vaccine or test option. So those employees who are not fully vaccinated and who work in a workplace in which the employer is allowing employees to be fully vaccinated or tested must provide weekly COVID test results such that they're receiving a COVID test no more than 7 days in between tests. Now, this requirement only applies if the individual is actually coming into the workplace. So if they're not coming into the workplace and they're not coming into work on a particular work week, there's no need to provide the test that work week, provided that when they return, they received a test within the previous 7 days. Non-fully vaccinated employees must be tested in accordance with these requirements unless testing conflicts with the worker's sincerely held religious belief, practice, or observance. And there's an exception to the testing requirement that's presented as mandatory in the ETS in the event that an employer receives a positive COVID test result in the past 90 days. So if the employee receives a positive COVID test result, let's say today on December 1st, the employer would be actually prohibited from requiring proof of vaccination for 90 days. So until January, February, until around March 1st, depending on how that 90-day count works. And the preamble to the ETS explains the reasoning here. And the reasoning that OSHA had for including this exception is the potential for false positives shortly after an individual tests positive, particularly within that 90-day window, despite the fact that the individual might not actually be shedding the virus and able to transmit it during that time. So OSHA is aware that they want to keep people working and they don't want to have people unnecessarily out of the workplace during a period when they're not actually infectious. The ETS describes which types of tests are acceptable, and they are those that are approved or authorized by the FDA. They just can't be self-administered and self-read unless observed by the employer or an authorized telehealth proctor. So this includes NAAT tests, including PCR tests and antigen tests, provided, again, that they aren't both self-administered and self-read. If documentation of a test result is not provided to the employer must keep the employee removed from the workplace until a negative test is provided. There is one exception that's explained in the frequently asked questions that were issued alongside the rule, that in the event that an employer and an employee are unable to provide positive proof of a negative test due to circumstances out of their own control. So for example, there's a delay from a testing laboratory that they're working with. OSHA might exercise enforcement discretion to not impose fines against the employer, even if they allow the employee to come on site, provided that they've made good faith efforts to comply with the testing requirement and their pattern or practice in the past is of complying with this. We wouldn't recommend hanging your hat on this exception, but there is a potential exception there in the event that there's circumstances out of the employer and the employee's control that prevent them from being vaccinated. Note that the ETS does not require employers to pay for the costs associated with COVID testing for employers who are not fully vaccinated. However, there might be other laws or agreements outside of the ETS that would require employers to cover the costs of testing. And that's the case in California and New Jersey, and potentially in other states or cities where laws require employers to pick up the cost of testing. So it's important if you're making a decision if you decide to implement a policy in which employees can be tested or vaccinated and want to put the cost of testing on employees, that's a time to reach out to counsel to make sure that there's no state or local obligations or other agreements that would require you as the employer to pick up the cost of testing.
Yeah, and
So now
just to
I'm
be
going to turn
clear,
it.
and yeah, no, thanks, Alex. And just to be clear on that point, a lot of the laws that we've been focusing on, mainly, at the request of different clients with operations in different states, I mean, you'll find that these laws that require compensation for either the time spent testing or the cost of the test itself, aren't really COVID laws as much as they are wage and hour laws in different states that have buried in them provisions which talk about an employer's, mandating an employee to get some form of a medical test, and then having to pay the employee for the cost of that test. So it might not be readily apparent in all cases, and some digging may be needed to determine whether your state would actually require it. So next slide. So I'm going to talk a little bit about the positive COVID cases. So the ETS talks about the fact that when an employee tests positive, regardless of their vaccination status, the employer must have a policy. We'll get to what that policy looks like in a moment. That would require the employee to promptly notify the employer if they receive a positive COVID test. In that case, the employee would be removed from the workplace until they either received a negative COVID-19 NAA or NAT test following a positive COVID-19 antigen test, or they meet the return to work criteria in the CDC's isolation guidance, which is a separate set of guidance that talks about the number of days, generally 10, after which an employee could return. Anyone could exit isolation with testing, or receive a recommendation to return to work from a licensed healthcare provider. So in other words, that's the general period of time within which somebody must be removed from the workplace. Keep in mind there too, there are state laws that might, or guidances that could require different time periods when it comes to isolation or guidance than what necessarily the CDC might require. So I think, again, it's an area where I think we have to be mindful of what the local jurisdictions say. To be clear, the ETS does not require employers to provide paid leave to employees who are removed from the workplace, but there too, just as with the testing requirement, there may well be laws in other states or jurisdictions that require an employer to pay for that time off. New York being one of them. Many of you may recall that New York has its own COVID leave law, which would entitle an employee, depending on the size of the employer, for up to 2 weeks of paid leave in the event that that person is subject to a quarantine or isolation order themselves. Of course, testing positive for the virus would be one such way to get yourself a mandatory isolation or quarantine order. So again, need to check on state laws to make sure that you're following whatever the state requirements are. Next slide. With respect to face coverings, as Alex pointed out, the option for testing within the ETS construct is testing and masking. Non-fully vaccinated employees who would come to work under a policy that would allow those employees to come to work must wear face coverings indoors and when in a vehicle with others for work purposes. The exceptions to that general rule would be when the individual is alone in a room with the door closed, or for a limited period of time, they could remove the mask while eating or drinking, briefly for purposes of a security identification check, or while wearing a respirator, for example, an N95 or a face mask, i.e. a surgical mask, or if the use is infeasible or itself poses a greater hazard. Example of that being, for instance, in a situation where one would have to see the person's face or their mouth. Maybe it's in a setting where others, lip read or need to see the individual's mouth in order to do their job, and would pose a risk to the health and safety of others if they didn't. The ETS does not require employers to pay for face coverings, but again, there could be state and local laws that may require it, or agreements that employers have with employees that would require an employer to pay for the cost of a face covering. Next slide. So just briefly on paid vaccination time, the ETS, I should say, also requires that employers provide a reasonable amount of time for employees to get their primary vaccine doses. That's up to 4 hours per primary dose must be paid. It cannot be offset by other leave, such as vacation or sick time. So you can't draw down on vacation or sick time in lieu of this essentially new bank of paid leave time. In addition to that, employers are required to give a reasonable amount of time and potentially paid sick leave for individuals to recover from side effects associated with the vaccine. The FAQs generally talk about the fact that if an employer makes up to 2 days of paid sick leave available to an employee per dose, the employer would generally be in compliance with what that requirement is. And you could, in that case, require an employee to use accrued paid or available paid leave, such as sick leave, but not vacation leave during that recovery period. So it's a little different than the time spent getting a vaccine when you're talking about the time spent recovering from side effects associated with it. Next slide. So in addition to all of this, there's the notice requirements, or in a sense, the policy requirements. So the ETS would require employers notify their employees about the requirements of the ETS and any employer policies that are established as a result of the ETS. That notification has to be in a language and at a literacy level that's understood by the employees. And you have to also provide employees with the CDC's key things to know about COVID-19 vaccine document. And you also have to be informed, or the employees have to be informed, that there are certain protections against discharge or discrimination for individuals who report work-related injuries or illnesses, people who exercise their rights under the law, that being the OSHA, the Occupational Safety and Health Act, or those who file a complaint of workplace safety. In terms of the policy requirements here, the good thing is that OSHA put out a set of formal template policies, one for employers that go the vaccine only route and one for employees that go the vax or testing/masking route. Both of those samples obviously quite good. I mean, OSHA developed them themselves under the ETS, but we have reviewed them, and we do think that there probably are some edits, additions, and revisions that could be incorporated to kind of bring in all of these notice requirements that you see on the screen. They're not actually all captured in the template policy, so we're happy to discuss that with you as well. But that is, of course, if and when this ETS goes into effect. Next slide. In addition to all of these requirements, the ETS would require that employers maintain records and make available those records to OSHA within 4 business hours if they are requested. That is, records of the policies that I just discussed. Any other records or documents that are required to be maintained by the ETS have to be provided by the end of the next business day after request. This is not unlike other requirements when it comes to production of documents to OSHA when requested in the context of policies and procedures around workplace safety. In addition to that, an employee's vaccine records or documentation or test results have to be provided by the end of the next business day to an employee following a request by the employee, so they do have a right to have that information. And the aggregate number of fully vaccinated employees and the total amount of employees at the workplace have to be provided to an employee upon request as well. So that's all information that the employer needs to maintain and be able to provide to an employee upon request, or in the case of the policies, to OSHA upon request. Next slide. Some additional information, there is enforcement mechanism in place that could result in fines up to $13,653 per violation, 10 times that for willful or repeated violations. And the idea is the ETS would remain in effect for 6 months, and that OSHA would continue to monitor the trends to see whether the ETS would need to be extended. Next slide. Okay, so let's talk briefly about the legal challenges, just so you can get a sense for what the landscape is. On November 12th, as Alex mentioned earlier, the Fifth Circuit issued a decision. They stayed the ETS and extended a nationwide hold on implementation. The court basically said that the ETS ran afoul of the statute in the sense that OSHA exceeded its statutory authority. Next slide. After the Fifth Circuit issued the stay, the case was consolidated before the Sixth Circuit by lottery. And while the Fifth Circuit stay remains in place nationwide, there now, not surprisingly, is a whole bunch of litigation in these consolidated Sixth Circuit cases on the continued viability of the stay, the continued viability of the ETS, the extent to which the agency may have overstepped its bounds or not in issuing it, The briefing schedule, meaning the schedule on which the parties, the interested parties, meaning those challenging the ETS and the government, on the other hand, are going to be submitting their papers to the court, is itself a subject of litigation. Because, and I can say this as a lawyer, the more lawyers you put into a process, the more litigation you're going to get. There's just, filings about when the briefing schedule is going to take place, whether it's going to involve the entire panel of Sixth Circuit judges or 3-judge panel, which would typically hear appeals. And so there really isn't a lot of clarity at this point, other than the fact that the court has set a briefing schedule for interested parties to file papers on the stay itself, with the final set of those papers to be submitted on December 10th. But there's a whole bunch of motions and applications about timing that have not yet been decided. And so it's not entirely clear whether the court will have a full set of arguments before them by December 10th, or whether there's still be more after that. My guess is sometime in the later December, early to mid-January timeframe, we should have a better sense of where the Sixth Circuit believes this is going to land. Next slide. Now, this sort of summarizes what I just described, but I think what most observers will say is that almost regardless of what the Sixth Circuit decides here, one way or the other, given the scope and the gravity of this rule, the potential effect, broad-ranging effect it would have on employers across the country, many do expect that the case will ultimately be heard at some point by the Supreme Court, and likely on some type of emergency basis, so that it wouldn't sort of sit there for 6 months, but that there would be some expedited process by which the court would actually hear this case. But it does have to get there, which means it has to go through the process of the Sixth Circuit. Next slide. Just real quick, there are state laws that go sort of in either direction here. If you're not already aware, Florida, Montana, and Texas have implemented either laws or executive orders that limit an employer's ability or a private entity's ability to require vaccine proof, either from employees coming to access a facility or from patrons who frequent a business. And that will tell you a bit in terms of where some of those states are in their views on at least the state governments are in their views on the vaccine mandate. Similar laws are in effect in Alabama, Arkansas, Kansas, North Dakota, Utah, West Virginia. The next slide will show that there are yet other states, or it doesn't show yet, but there are states in the other direction. There are states that actually require vaccines of employees in, for example, New York City, where you have to have a vaccine to be working in or patronizing a restaurant, bar, any stadium or museum or things of that nature. So there's clearly tension at the state level in terms of these rules. What the ETS says about all this is that, and if and when it were to go into effect, the intention of the ETS is to preempt inconsistent state laws. So some of the ones that we just saw from Montana, Florida, and Texas, for example, may be preempted in the sense that the ETS would supersede whatever those state law requirements are. Now, first, there's lots of questions before that would ever take place. One is, does the ETS itself survive judicial scrutiny? And two, if it does, do these provisions of the ETS survive judicial scrutiny in the face of those potentially conflicting state and local laws and regulations? That too would likely be the subject of litigation in each of those jurisdictions. Next slide. Okay, so I'll turn it over to Alex to talk about some religious accommodation request issues that we've been speaking to clients about.
Great, thanks, Evandro. So as I previously discussed last time I was speaking, the ETS allows for exemptions for employees in the context of a mandatory vaccination policy for those employees who are medically contraindicated to receiving the vaccine, have a medical necessity that requires a delay, or 3, that are entitled to a reasonable accommodation due to a disability or sincerely held religious belief. Now, of course, this hasn't come up yet in the context of the ETS, but as we've been advising clients on implementing mandatory vaccination policies over the past 6 months or so, we found that a lot of the action has been in the context of evaluating requests for religious accommodations. We wanted to provide a brief overview on the state of the law to the extent that it might implicate an employer that's on their own implementing a mandatory vaccination policy, or in the event that the ETS takes effect, we'll come into the prong number 3 on the number of exceptions that are allowed under the ETS. So as a general matter, employers must provide reasonable accommodations to employees if an employee requirement conflicts with a sincerely held religious belief, practice, or observance. And that's limited by what's called the undue hardship exception. And that states that the employer cannot accommodate the employee due to an undue hardship. So it would cause a significant difficulty or expense, or in the context of Title VII, would result in more than a de minimis cost to the employer. And we'll cover that in a little bit more detail later on. Title VII, which is the federal law that requires employers to offer religious accommodations, defines religion very broadly to include all aspects of religious observance and practice, as well as belief, and not just practices that are mandated or prohibited by a tenet of an individual's faith. Title VII protects beliefs, practices, and observances, which employers might be unfamiliar with. And it might include moral or ethical beliefs as to what is right and wrong, which are sincerely held with the strength of traditional religious views. And there's actually one case out of Ohio holding that veganism could potentially qualify as a religious belief. Now, that said, Title VII doesn't go so far as to protect political, social, and economic philosophies or personal preferences. So there is a line in the sand at some point when a belief is no longer considered religious in nature. That said, employers should ordinarily assume that an employee's request is based on a sincerely held religious belief, unless they have an objective basis, so something that they can point to for questioning either the religious nature or the sincerity of a particular belief, in which case the employer can make a limited factual inquiry and seek additional supporting information. So for those clients that have decided to go forward with implementing mandatory vaccination policies, some have decided to scrutinize requests for religious accommodations a little bit more closely by asking some follow-up questions. And some follow-up questions that clients have asked employees requesting religious accommodations are, how long have you been an adherent to the particular faith or religion to which you're saying that you require an accommodation due to? Have you received any other vaccinations as an adult? And if so, why do you require an exemption from this vaccination policy, even though you've received those other vaccinations? Or please clarify, in light of public statements by church leadership that receiving the COVID vaccine is morally acceptable and you should receive it, what specific sincerely held religious beliefs preventing you from receiving the vaccine? Now, that said, just because the church, whether or not an individual has a sincerely held religious belief is analyzed at the individual level. So even if an employer or an employee responds, or the church has indicated that an employee can receive a vaccine, if the employee's own sincerely held religious belief prevents them from receiving the vaccine and they can substantiate that, they still might be entitled to an accommodation despite the statements from the church. So you shouldn't give too much weight to statements from church in deciding an accommodation request.
Yeah, I think a main takeaway on the religious accommodation piece is that these are complicated questions to navigate. The good thing is, by and large, with an employer mandating the vaccine, particularly in a context where there's already a significant number of employees vaccinated, the number of religious accommodation requests, might not be tremendous, but I will tell you is navigating those requests with clients, they're complex and they're difficult, and asking follow-up questions is not, I'll say, kind of the right thing in every instance. Sometimes, depending on what the initial submission was, it could be viewed as risky, insofar as an employee could turn around and say that I've given you what you need, and further information requests feel like a failure to participate in good faith in the interactive dialogue. And it's not always the case that the answers you get are going to be helpful at all to clarifying whether this is truly a sincerely held religious belief, or give the employer any more comfort that they might be in a position to reject an accommodation request, or determine whether to grant it. So there is a lot of nuance here, and certainly worth discussing in greater detail if it's something that you're interested in pursuing. But as Alex said at the outset, it really comes up largely in the context of an employer that implements a mandatory vaccine policy with these accommodation exceptions, if you will, as opposed to an employer that does something other than a mandatory vaccine policy, where there's less likely to be, exceptions being requested. For example, testing, or nothing, right? Obviously, if you don't have a requirement, then there wouldn't be exceptions requested to that requirement.
Great. And this next slide just summarizes some examples of potential accommodations. And outside of the context of the ETS, so where we stand right now, employers generally have a fair amount of leeway in consultation with the employee as part of the interactive dialogue to have discretion in order over what the accommodation will look like. And typical accommodations that we've seen have been some combination of requiring the use of a mask or other types of PPE if the employee is going to come on site unvaccinated, requiring the employee to work at a social distance from others, requiring the employee to work remotely, having the employee submit to periodic testing, or reassigning the employee to a vacant position, maybe for which the employer isn't requiring vaccination, or in the context of the ETS, maybe one that would fall outside of the context of the ETS. For example, maybe it's performed remotely or at a workplace where others aren't present. Now, with the ETS, of course, any accommodation from a mandatory vaccination policy would likely need to involve both weekly testing and the use of masks, unless, again, the employer structures the accommodation such that the employee would fall outside of the scope of the ETS. So they're working from home, they're working outside, or they're working at a workplace where others aren't present. As a general matter, there's no obligation for employers to provide the accommodation of the employee's choice, so long as the employer provides an effective accommodation to that employee. Now, returning to that exception that I mentioned back at the beginning of this section, employers generally don't have a duty to provide an accommodation that would impose an undue hardship on the employer. Now, under federal law, under Title VII, undue hardship is defined as more than a de minimis cost or burden, which is a very low standard for finding undue hardship. That said, under some state and local laws, for example, under New York State, they've actually raised the level or the standard for undue hardship, such that it's defined under New York law to mean a significant difficulty or expense, which more closely mirrors the standard that we're used to seeing in the context of requests for an exemption due to a disability. Considerations that might go into a finding of undue hardship are not only economic costs, but also the risk of spreading COVID to others in the workplace. And according to EEOC guidance, employers in conducting the undue hardship analysis should rely on objective information, including whether the employee works outdoors or indoors, whether the employee works in close contact with others, including members of the public or higher risk populations, and also the number of other employees who are seeking similar accommodations. And finally, I just wanted to briefly touch on confidentiality of employee medical information, since this is a topic. Before the pandemic, it wasn't very common for large amounts of employee medical information to be floating around workplaces. And now, with the pandemic, with requests for accommodations, testing, vaccine information being collected by employers, this is an issue that's starting to arise more and more. And the applicable law that governs employee medical information is the Americans with Disabilities Act, which requires that employee medical information, which includes both information about an employee's vaccination status, as well as information submitted as part of an accommodation request. It must be kept confidential and also stored separately from other personnel records. And these requirements would apply to both of the requirements in the ETS to collect proof of vaccination from employees, and also the roster of every employee's vaccination status. Courts have found violations of the ADA's confidentiality requirements when employers have shared medical information with a colleague with no supervisory authority over the plaintiff. When an employer, actually after letting the employee go, merged the employee's medical records with their personnel file. And also when an employer left a doctor's note regarding an employee uncovered on his desk when others could view it, and then left his office. So the key here is to limit the extent of the medical information that you're collecting from employees. Before doing so, you should ask, is there a need for me to have this information? Limiting those within the business who have access to this information. So asking yourself, do they have a business need for having this information? And finally, to segregate employee medical information from any personnel records. We wanted to conclude before we turn to some questions by providing some action items for employers on the ETS. So the following elements of the ETS are scheduled to take effect on December 6th, which is actually next Monday, which is essentially everything other than ensuring employees who aren't fully vaccinated be tested on a weekly basis. That requirement is currently scheduled to take effect on January 4th, 2022. Of course, all of this is subject to the current litigation before the Sixth Circuit. And given the current briefing schedule, the briefing on the stay isn't even scheduled to conclude, as Avandra said, until December 10th. So it's highly unlikely that the ETS is going to take effect next Monday.
Yeah, in fact, I mean, if in OSHA's own website at this point now says recently that employers need not implement until further notice, because obviously the litigation is going to impact the extent to which this can even be implemented.
Yeah, and that said, to avoid a situation where you're caught flat-footed in the event that the stay is lifted, there are still some things that we would recommend doing in the event that you're an employer that would be covered by the ETS. So you're a large employer with more than 100 employees. We would recommend at this time starting to draft an ETS compliant policy. And as Avandra mentioned, OSHA has actually released a pretty good model policy of their own, preparing to distribute the required information to employees, and collecting or preparing to collect information about each employee's vaccination status. So since those are each items that could require some lead time to get your process set up on the back end. That said, even though we recommend drafting an ETS compliant policy, we don't necessarily recommend going forward and distributing that until the litigation before the Sixth Circuit or even the Supreme Court is resolved. And this is true even if, outside of the context of the ETS, you're contemplating implementing your own mandatory vaccination policy. If you want to implement your own mandatory vaccination policy, I don't see any reason not to do so while this litigation is being resolved. We wouldn't recommend just using the ETS compliant policy, which contains some language that even if you're an employer wanting to move forward with a mandatory vaccination policy, you probably wouldn't want to include. As Avandra discussed, there's pretty strict requirements on employers in terms of how quickly they have to provide information to employees or to OSHA upon request. And that's all included in OSHA's model policy, which you probably wouldn't want to include if you're just creating a mandatory vaccination policy on your own. So we would recommend, to the extent that you want to implement a mandatory policy before then, and you want to use the OSHA standard, carving those provisions out that aren't necessarily quite as employer friendly.
So with
And
that, we will open it up to questions. I think we see some in the Q&A.
Yeah, I'm going to start with a question, then I'll have Chase pull from, because I know they've answered some questions, and I'll have him pull also. Jill, if you'll do the same, pull some questions that seem to be asked more often. But I wanted to start with trying to put some of this litigation in perspective. Obviously, there's a history of courts striking down the use of the ETS process. And so if we assume, just for purposes of this question, that the courts do strike down the use of that ETS process, what is the likelihood of OSHA being able to implement this mandate through normal rulemaking process? Are you seeing some strong arguments in the litigation outside of just the process itself that gets to the substance of the rule? And so what's the likelihood of it after that?
Well, listen, I mean, if OSHA strikes it down, if the court strikes it down based on the finding that OSHA hadn't met its standard of, demonstrating a grave danger to employees, and or that the rule itself as promulgated, was not sufficient to kind of meet that concern, I think that does, in a way, send OSHA a little bit back to the drawing board on how to come up with a policy, even through rulemaking, that would meet judicial scrutiny. At that point, the grave standard, the grave danger standard wouldn't necessarily be applicable. But at the end of the day, OSHA would need to promulgate a rule that is, intended to and does, in fact, protect the health and safety of the employees covered by the rule. in a manner that is not going to be subject to judicial scrutiny from employers who are being required to comply with it. So the size of the employer matters, presumably, the industry, the jurisdiction, the transmissibility of the virus. There are lots of question marks that abound here, and so I think that in any event, OSHA is going to have a tough time coming up with a rule that's going to be sufficient to withstand, all judicial scrutiny. And so I'd be curious to see what that looks like. It might be more industry based, than sort of broad ranging. That's one option. And it might, cover fewer, as a result, cover fewer employees and potentially higher risk industries. But that's where I think this goes if the ETS is struck down.
Okay, thank you. Chase, did you want to ask a question?
Yeah, so several questions come in just sort of for remote workers who may occasionally travel for work to a client site or who occasionally get together in person, maybe once a month, twice a month. How does the mandate sort of apply to those remote workers? We know kind of generally you don't have to do it for a remote worker, but they're going to have some interaction with a client or with other colleagues at a work site.
Yeah, I mean, I think interaction with colleagues at a work site, at a client site, or just being indoors in the context of performing their job, is likely going to be enough to bring them within the scope of the ETS. And that doesn't necessarily just mean in the office. It could mean at a client site or somebody or somewhere else where the employer does business. So that's, the ambiguity around that is sort of one of a number of reasons why it's being subject to some challenge. But I think it's fair to say that if this rule goes into effect as written, there isn't really much of an exception except for employees who truly work remotely on a full-time basis and don't work in a client site or the employer site really at all.
We had a question come in that asked, understanding that the employer must pay for time taken to receive the vaccine. Can you speak to the employer's obligations in terms of pay when the individual must do weekly testing or will do weekly testing?
Yeah, so the law does not require the ETS, I should say, does not require an employer to pay for an employee's time spent getting tested or for the test itself. And that's intentional in a sense. The preambles and the information that kind of precedes the rule itself makes clear that it's intended to incentivize employers and employees to get vaccinated as the primary mitigation strategy and to use testing sort of as an alternative. So, the ETS is not looking to encourage employers to have employees get tested as opposed to being vaccinated. That said, there are a host of state and local laws, particularly state laws, that could require an employer to pay for an employee's time spent getting tested and or the cost of the test itself. California is an example. New Jersey is an example that requires an employer to pay for the test itself. And the question about paying for the time spent testing really turns on sort of the age-old question of what is considered hours worked, right, under the FLSA for one. And there are ways in which to interpret the FLSA depending on the circumstances and setting the testing up so that it might not be covered by the Fair Labor Standards Act in terms of hours worked, but that might not necessarily answer the question if you're in the jurisdiction that itself has a broader definition of hours worked, in which case you would have to pay for it.
Thank you. It looks like we have run to the end of our time. There are still a number of questions. What we will do is we always keep a copy of the questions. We will certainly address the questions that we can. We'll reach out and see if we can get some additional clarification if needed. But we certainly, Alex and Evandro, appreciate you taking the time to do this presentation. For our clients, it's a very important subject that most employers are wrestling with right now. And as always, you did a fabulous job. So we appreciate your time. And thank you, everyone. Thank you, everyone, for joining. We will be sending out a follow-up communication. All right. Thanks for joining. Amber, if you want to close us out.
Yes, thank you everyone for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recordings in the follow-up email. If there are any portions of this call that you missed, by Friday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us and have a great day.